Hello and welcome to Win Without Law School. In today's class, I'm going to talk about how to approach settlement once you've created a case strategy in a modification and/or enforcement case. I'm Arizona lawyer Julie Lebenz. Thank you so much for joining me today. A lot of people just go straight to the courtroom and file court papers, and that's definitely something you can do with a modification or enforcement. But there's also the opportunity to engage in settlement negotiations and see if you can resolve the matter right off the bat and lodge a proposed order instead of going through a contested process. So once you've created your case strategy, then you can make a settlement offer, because once you have your strategy, you understand what your requested outcome is. And so then you're in a position to make a settlement offer. You can engage in negotiations, see if you can resolve the issue. And then if you can put that agreement into a stipulated order and file that with the court. And then once the judge signs the order, your matter is resolved. So certainly you can go just the contested route, in particular if you're not able to reach an agreement. But what we're going to talk about here is engaging in negotiations at the outset in an effort to just resolve the case in full. Now, as your case is unfolding, let's say you try this, it doesn't work, you have to go to court, you still continue to engage in negotiations. The timing may just be right a little bit later down the road. So I don't want you to think that this is a one and done process, like you're always trying to settle and engage in negotiations. But this is a little bit different because it happens before you even file your case. And again, you don't have to do it this way, but this is an option to see if you can just get a nice agreement into place and move on without a lot of back and forth. Okay, so first you're going to create your modification and/or enforcement case strategy. So if you're wanting to modify, then in creating your case strategy, remember you identified what you're seeking to modify. Spousal maintenance. If you're seeking to modify spousal maintenance, is it the amount, the duration, both? Are you wanting to terminate it? If you're wanting to modify legal decision-making, are you looking to go from sole to joint, from joint to sole? Is it on all four categories? Education, legal decision-making, education, healthcare decisions, religious training, and personal care decisions, or just on education, for example. For parenting time, what are the changes you want to the schedule? In other words, what is the new year-long parenting plan you'd like the court to order? And then for child support, what's the requested change? What's the current amount? What do you want to change to? Are you wanting child support to be terminated? Did one of your kids age out? Are you wanting changes to the child tax exemption? So identifying what you want to modify. And of course, it can be more than one thing. It can be legal decision-making and parenting time and child support. It doesn't have to be just one thing. It could be more than one, but identifying what you're seeking to modify and what your requested outcome is. That's going to be the key points of creating a case strategy. And then if you're looking at enforcement, then what order or orders within your decree or establishment order do you believe have been violated? So first identifying each violation, and then what is your requested relief? What do you want the court to do as a result of each violation? So that's going to be your case strategy. So there's a question about how about parallel legal decision-making? That, in my mind, would be joint legal decision-making. That's going to be where both parents have equal decision-making rights. Okay, so once you know what you're requesting, then you're in a position to make a settlement offer. And with a settlement offer, I recommend that you put your offer in writing, because if you're just going to talk about it back and forth with the other side, that there can be misunderstandings. People can hear what they want to hear. People can claim you made an offer you didn't make. So I definitely recommend that you put the offer in writing. Additionally, I recommend that you include an offer deadline. If you just make an offer and it's just out there, there's no real um, reason for the other side to act and engage with you in negotiations. So have a deadline, and what would happen after the deadline is that you would file court papers. So you're basically saying, look, respond to me by the end of the month, whether or not you agree with my proposal. And if we don't have this resolved by the end of the month, then I'm going to file court papers. So that can keep moving things forward. And then share your written settlement offer with your opposing party. So put it in writing, include a deadline, make sure it's clear, have all the details you need, and then of course share it with the other side. And from there, you can engage in negotiations. We've got a question about legal decision-making. How about splitting, one parent does education and one parent does medical? Yes, you can divide up legal decision-making so that one parent makes the major decisions for education or has final decision-making on education or medical. So you can do that, but of course, you'll need the parents to agree on that situation. And just because one parent has sole decision-making doesn't mean the other parent is denied information about their child's education or healthcare. This parent with sole decision-making is supposed to keep the other parent informed. Okay, let's look at some tips for writing a settlement letter. Number one, you're going to want to be polite. You're not going to necessarily get the other side to agree with you if you come in with a really insulting letter, or threatening or something like that. It doesn't mean that you can't make some demands and show that you're serious, but I wouldn't be insulting or, do something that's going to maybe cause the other side to not even really read the letter. Make sure you're clear and concise. If you have somebody else who could review the letter before it goes out, to make sure that your language is clear. For example, if you are suggesting to change the parenting plan, then be very specific about what your requested changes are. What's the changed pickup time? What's the change to the drop-off location? What's the change in the days? You want to have as much detail as possible so it's very clear. Also, explain your next steps if no agreement is reached. And this can actually apply both ways. You can explain the next steps if an agreement is reached. In other words, okay, if we're in agreement, we'll put this into a stipulated order and file it with the court, and it's a done deal. On the other hand, if we don't resolve these issues, then I'm going to file court papers by such and such date. And, we can take this to the court, we can explore mediation or have the judge decide. Also, if you're intending to hire a lawyer to handle the matter in court, if you can't reach an agreement at this stage, you can let the other side know that as well, that if we can't resolve this, then I'm going to end up hiring a lawyer and I'm going to ask the court to order you to pay my legal fees. And be sure to include a deadline. If you don't have a deadline, then your offer may just languish. And then, you're asking the other side why they haven't responded. And they may be like, well, you didn't tell me I needed to respond by any certain time. And then you're just kind of in this place where you're stuck. So include a deadline. You can be flexible with the deadline. If something comes up and the other side gets sick and, they need a little bit more time to consider your offer, certainly you can extend the deadline, but I would extend it to a certain date. Okay, you need more time. Well, how much? All right, I agree. You can have an additional week. Now the new deadline is this date. So again, stay in that place where you're being clear and concise, and also looking forward to do things to keep making progress. Once you've written your offer and it's concise and you're ready to share it, then you need to share it with the other side. You can do that by email. You can do it by text. Of course, text may be a little more difficult if it's more detailed. You can do it a written letter and send it by mail. You could do a written letter and hand deliver it. But bottom line is, you want to confirm the opposing party received it. And you want to confirm that they're aware of your response deadline. So, hey, did you receive my offer? I'd like for you to respond by Friday, and see if you can get a yes or no. So what you could do is send the offer in an email or hand deliver in a letter, and then follow up by text. Hey, look, what do you think about my settlement offer? I did put that deadline of Friday in there. If you need more time, let me know, but I would like a response by Friday. Thank you. So again, staying polite, staying professional, and then constantly trying to move the dial forward. Keep in mind that you should be open to negotiating. So it's not this thing where you just put your offer out there and then it's take it or leave it. Of course, you could take that position. And if you feel very strong in your position, that's an option. But the other option is to be ready to negotiate. And maybe you want to go negotiate, but you're not getting any communication from the other side. So what do you do if the opposing party doesn't respond to your settlement offer? Well, I'd again confirm that they received it. Make sure there's not just some communication breakdown where you're waiting for a response and they don't even know the offer's pending. So make sure you're on the same page and that they got your offer and they've read it. And then if they just say, no, I wouldn't stop there. I would be asking the other side to specifically identify what about your offer they object to, and potentially trying to engage them in this discussion. So, well, what about my parenting plan modification don't you like? Is it the change to the time? What would you prefer? You can start engaging in a conversation, and it's around questions. So you're not telling them, but you're asking them, okay, well, what about the legal decision-making modification don't you agree with? What about the change to child support? You can gather information and start drawing them into a negotiation through your questions. Also, through those questions, you may be able to narrow down what's really at issue, because maybe they agree to 5 of the things you've proposed, but it's just the 6th thing that they don't agree to. And so through this conversation, you may be able to find, okay, we're on the same page with these 5 things. It's just this number 6. So can we negotiate on that? Or you as the proposing party, do you potentially want to drop that and just lock in the 5? So, that's where the negotiating can come in. You can, if you're still getting a lot of resistance, remind the other side that if they won't engage in negotiations with you, then you're going to go ahead and file papers with the court. So unless they want to deal with going to court and the judge and an outcome that they may or may not be happy with, now's the time that they could come to the negotiation table with you and resolve it. So just, you can remind them of that, in particular, if you think that that would be persuasive in your case. Now, what if you reach an impasse? Okay, so you have negotiations going on between you and the other side, but you've reached an impasse. Let's say it's on changing your parenting plan. You want to change to an every other week, and your co-parent wants to stay with what's often called a 5-2-2 or a 3-2-2 plan, where the kids are with one parent Monday, Tuesday, the other parent Wednesday, Thursday, and then you alternate every other Friday, Saturday, Sunday. And so some parents think that's too much back and forth. Other parents like all of the contact. And so what if you're looking at this situation where one parent wants every other week and one parent wants the 5-2-2 or 3-2-2? So you've reached an impasse. Well, look at the big picture. Okay, is there any way to reach a middle ground here? For example, could you do every other week in the summer and keep the 5-2-2 during the school year? Maybe there's a compromise there that gives you a chance to try both schedules. And then maybe after you've tried both schedules, you decide you reach an agreement as to which one you both agree is better, and move forward with that. So is there any way that you can take these two competing positions and find a middle ground? Also assess your case. Like, the things that are in dispute, are they big enough to take to trial Is this more of an emotional thing, or is this a really serious, important thing that needs to be addressed and resolved? Is this worth taking to court? You may find that you need to relax a bit in the negotiations and be a bit more flexible if the things that you're fighting for aren't really worth, a year-long court battle over. Also, find ways to get creative. If you've got this situation of the competing, essentially equal parenting plans, but is there something else that the other side would be willing to negotiate with? Hey, look, I know you don't want to handle any transportation to the kids' extracurriculars, so I'm willing to do that during your week if we could go to this week on, week off. Is there some way you can get creative to resolve the current impasse? And then consider requesting mediation. In various counties across Arizona, there are free mediation services. There's some paid for options as well. Sometimes getting a neutral third party involved can be helpful in resolving the conflict. What happens if you reach an agreement? If you do, then the terms of the agreement need to be put into a stipulated order. So you're going to need to draft a stipulated order to modify and or enforce. So you can find a post-decree order and proposed court order to modify and or enforce. So what you're looking at here is going on to your county website, county court website, looking at their proposed forms, going into the post-decree or post-order section, and then looking at orders to modify and or enforce and using those to create a proposed order. If you're going to take those and then draft your own order, there's two parts. You're going to have the findings and then the court orders. So you can start by drafting the findings, which is explaining, look, on this date, our original divorce decree was entered or our custody establishment order was entered. And these were the terms that we now want to modify. So naming each term as it was in the original order, and then explaining your agreed upon change, and then drafting the orders based on what your agreement is. So the court finds and the findings are going to be about what's happened up till this point and what the terms of your agreement are. And then the orders are going to be making those terms of your agreement into an order, changing your underlying order or enforcing it. Share once you draft this proposed stipulated order, share it with the opposing party to see if they have any objections and provide a response deadline. So this is where you can work together to create this final draft of the proposed order. And then once you're ready, you can file that with the court. So that slide just went twice for some reason. So once you've agreed upon the language in the stipulated order, it's all ready to go. Then you're going to lodge it with the court. In other words, you're going to e-file it with the court. So that's the final step there. So just some ideas. This is not a requirement, but if you're looking to resolve something that needs resolution in your case and you don't want to go through a long drawn out court battle and you think the other side is open to these changes as well, then this is a great time to do it before you file, reaching out with a detailed settlement offer. So create your case strategy, figure out what you want, put that into a written settlement offer, include a deadline, engage in negotiations. And if you're able to reach an agreement, put that agreement into a proposed stipulated order to modify and or enforce, and then file that with the court. Once the judge signs it, the order's in place. All right. Thank you so much for joining me today. If you have any questions, feel free to join us for the live Q&A, and that's where we'll be addressing all of the questions. This is, of course, the modification section. You can find a lot more information about legal decision-making, parenting time, in different areas of the Win Without Law School members area. So feel free to jump in there.